Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss about the family law, top 5 case laws of family law. I am Jagannath Kulkarni and I welcome you all for today's discussion. Now, when we talk about the family law, it is required that we must understand what is the family law is and for what it is meant. Even though most people want the things that to go well, not everything is always perfect in our families, obviously. Just like charity, even the conflict begins at home. And sometimes the issues can get resolved within the house, and there are times when you need external help. It is usually legal assistance through family law, which manages the cases concerning domestic disputes and family disputes, covering both criminal law and civil law. Now, when we talk about the family law, there are different distinctions, or we can say branches of family law. First of all, we talk about the marriage and divorce. Again, in marriage and divorce, especially in our country, India, we have it according to the religion. Like for Hindu, we have the Hindu Marriage Act of 1955. For Muslim, we have the Muslim Personal Law. At the same time, we also have the Protection of Muslim Women, Protection of Rights on Marriage 2019 Act. For Christian, again we have two different acts. One is the Indian Christian Marriage Act of 1872. Another is Divorce Act of 1869. For again Parsi, we have the Parsi Marriage and Divorce Act of 1936. Of course, these are the British era act. While we talk about the welfare of children, again, in case of Hindu, we have the Hindu Adoptions and Maintenance Act of 1956. And for others, we have the Guardians and Wards Act of 1890. While we talk about the court system for family purposes, we have the Family Court Act of 1984. And for property, we have the different acts, but while we talk about the Protection of Women from Domestic Violence Act of 2005. Of course, we have the Indian Succession Act, Hindu Succession Act for the property purpose and transfer of property from one generation to the next generation. The top 5 case laws that we will discuss today about the family law, the first and foremost is Commissioner of Income Tax versus Gomedali Lakshminarayan. Second is NG Dastane versus S Dastane, which talks about the cruelty under family. Then we have the Neeraja Saraf versus Jayanta Saraf case, which talks about the annulment of marriage or cancellation of marriage. The next case we will discuss about the Roxan Sharma versus Arun Sharma. It is about the custody of child. And lastly, the most controversial maintenance lawsuit we will talk about is Muhammad Ahmad Khan versus Shahabanu Begum and others. So these are the 5 case laws those we will discuss today. So the first case is Commissioner of Income Tax versus Gomedali Lakshminarayan. It is year 1935, pre-independence era. The issue is whether the property in hands of sole surviving co-parsoner in case of Hindu undivided family should be taxed as his individual property or that of HUF, Hindu undivided family. And the court said HUF, that is Hindu undivided family, may consist of single male member and his wife and daughters. So there is nothing in Wealth Tax Act to suggest that Hindu undivided family unit as assessable unit must consist of at least 2 male members. And joint status of family does not come to an end merely because for the time being there is only one male member of family. So this is the contention of court. Also, it said there is a sharp distinction between what is understood in Hindu law by HUF, Hindu undivided family, and co-parsonery consisting of male members. Also, it said under Hindu law, sole surviving co-parsoner has wide powers to deal with property, but subject to rights of female members also. regarding maintenance, marriage expenses, adoption by widow, etc. So this is one landmark case while the property is concerned or tax assessment of is concerned about the Hindu undivided family HUF. The next case that we will discuss today is the NG Dastane versus S Dastane. It talks about the cruelty under marriage. It is All India Reporter year 1975. It is decided by Supreme Court, paragraph 1536. And in this case, landmark case, the court has given the 5 tests while we determine whether a given conduct amounts to legal cruelty in marriage. First, the alleged acts which are constituting the cruelty should be proved according to law of evidence. Whatever law of evidence is prevailing in the country, it should be proved according to that law. Secondly, there should be an apprehension in petitioner's mind of real injury or harm from such conduct. Whatever conduct is alleged, so there should be apprehension in petitioner's mind. Third is apprehension should be reasonable, having regard to socio-economic and psychophysical condition of parties, both parties, socio-economic condition and psychophysical condition. Fourth test is the petitioner should not have taken advantage of his or her position while filing the petition. And lastly, petitioner should not by his or her conduct have condoned those acts of cruelty. So this is the NG Dastane versus S Dastane, which defines the legal cruelty or which gives the tests to determine whether a given particular conduct is legal cruelty or not. The next case that we will discuss today is Neeraja Saraf versus Jayanta Saraf. The case citation is year 1994, volume 6. We can find it in Supreme Court cases, page 46. This case, it has been said by the court that is no marriage between NRI, non-resident Indian, in this case men, that is Jayant Saraf, and Indian woman, in this case Neeraja Saraf, which has taken place in India may be annulled by foreign court. So the marriage which has solemnized in India can be annulled only in India by Indian court, not by foreign court. This is the first thing. Second, the court said provision may be made for adequate alimony to wife in property of husband both in India as well as in abroad. Then the court also said the decree granted by Indian courts may be made executable in foreign courts both on principle of comity and by entering into reciprocal agreements such as section 44A of CPC, Code of Civil Procedure, which makes a foreign decree executable as it would have been a decree passed by that court. So this is simple. It said the marriage solemnized in India can be annulled only by Indian court. So simple. Neeraja Saraf versus Jayant Saraf. Next case is very important when the child custody is concerned, and this landmark case is Roxan Sharma versus Arun Sharma. The case citation is year 2015, volume 8, Supreme Court cases, and page number 318. The issue raised was whether a father can be given custody of child who is minor and whether mother can be restrained from taking custody of child afterwards, after beyond 5 years. Now, custody of child below 5 years of age should be given to mother unless it is proven by father that custody of child to that mother would hamper the upbringing of the child. But remember, the court also said the burden of proof lies on father, lies before father. Then the word ordinarily, which has been used in clause A of section 6 of Hindu Minorities and Guardianship Act 1956, the court said it is the presumption in favor of mother with rebuttal. So what the law has mentioned already, the court has interpreted that clause wording in this way. Also, father's background and other relevant factors comes into consideration only when they doubt suitability of mother, otherwise not. Father is not working, he was alcoholic, drug addict, member of narcotics, joined rehabilitation, won't matter unless and until they doubt the suitability of mother. Otherwise it's okay. Also, the further the court said, the Hindu Minorities and Guardianship Act, which popularly we call it as HMG, this act of 1956 protects father's right also as guardian over property, but not over child who is especially below 5 years of age. Looking at the delicate age of the child, the court has given such decision. Also, no provision of any law or act disqualifies mother with custody of child after 5 years of age. So the mother cannot be deprived afterwards also, cannot be restrained from taking custody of child afterwards of 5 years of age of that child. Also, child's paramount interests would be served by mother. This is important. Child has been given the utmost importance. Child's interest should be protected. This is so simple. Also, in this case, what happened ultimately is mother was given interim custody of child because the father failed to prove that mother is unfit for custody of child. So as we say, the burden of proof lies with the father, not on the mother, that mother is unfit to take care of the child. And today's last case that we will discuss is the landmark maintenance lawsuit of Muhammad Ahmad Khan versus Shahabano Begum and others. The case belongs to year 1985, decided in Supreme Court, available in Supreme Court Reports, Volume 3, page 844. This is the controversial maintenance lawsuit. Now, why controversy? Is because of the Muslim personal law and the other laws those are prevailing in our country, which are considered as a secular law, which doesn't look at the what is your religion, what is the religion of the petitioner, defendant, and so on. No, the law which are secular, what the law does in case of the personal law, just to protect the weaker sections in the society. Now, Supreme Court granted the maintenance to divorced Muslim woman, in this case Shahabano Begum, irrespective of what the Muslim personal law says. Whatever has been mentioned, provided for in Muslim personal law, the court said, irrespective of that, we will grant the maintenance. And section 125 is the most important in this case of the Code of Criminal Procedure, because the court said that it is a secular law. It is not related to any religion, any caste, and so on, and is equally applicable on all religions, so also on Muslims. And there is no conflict between provisions of section 125 and those of Muslim personal law on question of Muslim husband's obligation to provide maintenance for divorced wife who is unable to maintain herself. She requires maintenance to survive on, and that's the reason why the maintenance has to be given even in case of her religion, irrespective of the religion being Muslim. A Muslim woman is entitled to maintenance even after period of iddat, because period of iddat provision is available in Muslim personal law. But what the Code of Criminal Procedure section 125 provides for is important. Remember what has been said earlier. Only such a householder who practices the restraint in taking care of his family shall acquire family happiness and achieve higher social status. Who said this? No else, but it is available in Rigved, our old book, old traditional law, old religious law, religious book, we can say. In Rigved we can find this quote. So with this we come to the conclusion of today's session. Today we have discussed the top 5 case laws of family law. Thank you. Thank you very much.